the regular meeting of the Hubbardston Planning Board. Planning Board meetings are broadcast live and digitally recorded. This meeting is being held both in person and virtually through Zoom, so that members of the board as well as members of the public can participate remotely. First on the agenda, we have public comment. Do we have anybody here from the public who is present to comment, either online or in person, for anything that is not otherwise stated on the agenda?
Yes.
Yep, go ahead.
Nathan Boudreau, Town Administrator, Town of Hubbardston. Thank you, Mr. Chair. I would like to notify you of the accepted resignation of the Chair of the Economic Development Committee. This has kicked off what we were hoping for is a late summer, maybe early August, mid-August joint session between the Planning Board and the Select Board. It is my hope that the town planner would be able to, I'm going to say the word host, but we just need to have a conversation about the values of the Economic Development Committee, what they can do to help the town, and what the marching orders are. With currently 2 members, one being Katie Young and the other being the Planning Board Chair, and 1 appointed member, there isn't much they can do right now. And with the prior chair having recently resigned due to personal matters, I think it's a good time to reevaluate what that committee can and should do to assist in economic development and planning initiatives. So just keep an eye out for that. I thank Alec for offering to host that, and I look forward to an interesting session whenever that may happen.
All right, thank you. Well, we obviously thank the chair for her service over the years, and look forward to kicking that off. Anything else for public comment from anybody online or anybody in the room? All right, moving forward to acceptance of the previous meeting's minutes. The minutes were made available to the planning board, both through the drive and through email and through their packets. Would somebody like to, we'll handle these through our usual process, which is to handle corrections during the discussion portion. Would anybody like to make a motion to accept the previous minutes?
I'll make that motion.
I second that.
All right, hearing a first and a second. Any corrections?
I have no corrections on my end.
I'm all set.
We're all set, Mr. Chair. And you're muted.
So hearing no corrections, calling a vote, and it's a roll call vote because members are participating online. Mr. Steiger?
Aye.
Jack, aye.
Ms. Stack and
Aye.
Mr. Holman.
Holman's aye.
Excellent, thank you, and the chair is aye, the minutes are accepted. So moving forward into new business, we have a discussion on some of the comments coming back from the town council on the amendments that have been presented for the bylaw revisions. And I thank everybody for their attendance for this evening. This is our primary matter on the agenda for tonight. So with that, Alec, can you take us through some of the changes? Alec and I had caught up about these and kind of, we did an initial review for feedback and decided that there are some matters here, none of it is earth-shattering, but that there are some matters here that we should bring back in front of the board in order to have a general consensus, if not a vote, on how we want to approach some of these. So, Alec, can I turn it over to you?
All right, thank you, Mr. Chairperson. I'm going to bring up my screen share so that we can walk through the document. Bear with me while I get that up. So we'll go in order. We specifically have feedback and commentary on Article 26, Article 27, and Article 29. That is the grid scale battery energy storage systems, the accessory dwelling unit, and your site plan review revisions. We do not have feedback from KP Law on the floodplain bylaw, but it's my understanding that Leanne has sent that up back to the Department of Conservation and Recreation, who in their authority can review and confirm that that bylaw is sufficient.
Excuse me, Mr. Wade?
Yep.
Are we sure about that? Have you looked at the most recent document that I sent you?
I have not had an opportunity to review the motions.
I want to say that within the parameters of the motions, there are suggestions for all four. She does line it up decently, whereas Bess is the only one with two options that, sorry, I muted myself, that says either take it off the table or do X. If you open that up, Carolyn does do the lion's share of our work for us, and we will just need to choose a direction, kinda. It's a choose your own adventure book.
Okay, bear with me, I'll get that on my screen instead.
The packets you guys have the KP Law
It's
motions.
a real small.
No.
Lettering.
In the packets, it lays out the motions too, it's
Oh, yeah,
highlighted.
no, I understand that, it's just reading this is like.
Yeah, I couldn't get it any bigger.
No, I get it, it's just really small.
It is what it is.
See if I can maybe.
Because there's some
Hey.
comments that they made here.
All right, I am bringing up now, just if anyone could confirm that the screen share is up and running.
Yes.
Okay, fantastic. So let's start with Article 26, battery energy storage systems. Sorry for the scrolling, everybody. It is a long Word document. Okay. You'll see that. Oh, I did not realize this is how she frames it. Give me a second. She puts the motions at the end. Okay. Carolyn has proposed two different options that we could pursue for the battery energy storage systems. Carolyn has noted that due to 2024 revisions to Mass General Law passed by the state legislation, they're working on their own version of regulations for grid scale battery energy storage systems. The concern that Carolyn has and has raised to us is that this could prompt the Attorney General's office to deny our battery energy storage bylaw on the basis that state regulations are incumbent. I do not necessarily agree with that. I agree that it could happen, but I don't necessarily agree that you should take it off the table or postpone this article indefinitely. It's my opinion that the board has worked hard on this article to date. You've taken public input, and we do not expect any state regulations to be passed until July 1st of 2026 roundabout. So in the interim, I believe it's within the board's purview to pass its own bylaw, and noting that the Attorney General made even note saying that you will have a bylaw that's not enforceable or only partially enforceable after that date. In the interim, I think it's entirely reasonable and valid to bring forward your bylaw. But that being said, Carolyn has provided us with two separate motions. either one motion to indefinitely postpone or effectively to pass over the bylaw, the simple majority would pass, or a motion that would incorporate some revisions. Let's talk through these revisions real quick and just discuss what the impact they are to the bylaw. All right, you'll see Carolyn writes as the secondary option if you choose to proceed, a motion to amend the zoning bylaws by adding the new Article 23, which will read grid scale battery energy storage. And the revisions are as follows. Amend section 2.1 to add the end section, provided however that tier 1 vests with an aggregate energy capacity of less than 0.5 megawatts are subject to the requirements of this bylaw. So it'll be rewritten, provided however that tier 1 vests with an aggregate energy capacity of less than 0.5 megawatts are subject to the requirements of this bylaw. And now secondly, I'm going to pull up a track changes version of the other so that you can actually see what these look like. And that's probably the most effective way to do that. All right. You should see Article 26 on my screen, and we're going to jump comment to comment. Sorry about this, everybody, that's the wrong version. Oh, that's the wrong button.
So while Alec is grabbing that, just to entertain some of the discussion, my personal opinion on this is that we should move forward, because if we don't move forward, this could prevent us from ever imposing some form of regulation. So yes, we absolutely run the chance of having it struck down by the Attorney General, but with the way the Attorney General had previously blue penciled our articles together, where battery energy storage systems are allowed in all zones, we either need to fix that through regulation, or it's ultimately going to become the subject of litigation. So this is our opportunity to try to do something about it. Anybody else any general thoughts they want to share before we get back into the details of it?
Alec, so if I heard you correctly, you anticipate in 2026 that the legislature is going to put some very specific regulations in place for the for large-scale grid-scale battery energy storage system. Did I hear you correctly?
That's correct. Specifically for installations that are 0.5 megawatts or fewer, they will put their own regulations together. Okay. For installations that are greater than 0.5 megawatts per hour, there's an expectation that the state will extend a utility company exemption to those installers.
And what does that mean? If I can, I mean, can you interpret that for us, what that means?
Yes, so certain use types under Mass General Law are protected. They're protected so that the state, so that for the purposes of the state, they can guarantee that certain businesses are allowed to continue operating. So for example, in the 1980s, the state through Mass DEP passed regulations on hazardous waste facilities and commercial dumps. And the state has said that towns, after the date of those regulations being passed, can no longer exclude those use types in their town bylaws. Towns that had already gotten on board and passed an exemption, they're allowed to continue excluding those use types. But this is an effort by the state to create reasonable regulations that are meant to protect those areas that are sensitive and protect areas while the use is still allowed to go forward. For uses over 0.5 megawatts per hour, the expectation is that they're going to extend an exemption, but clearly outline what has to be followed for those use types to occur. For installations under 0.5 megawatt hours, those are expected to have to comply with certain regulations, and then towns can regulate them further through reasonable conditions and simple permitting, like the site plan review.
Yeah. But based on the way that we have defined grid scale, it's the 0.5 or greater, correct?
Yes.
Alec?
Can you repeat the question? I'm trying to understand it.
So based on the way that our grid scale bylaw is worded, right? This is really primarily for tier 3, which is greater than 1 megawatt hour.
Tier 3 is probably the largest outstanding. That's where you're going to see the utility exemption come into play. Anything under tier 3 is where you're going to see the local regulations promulgated that then you can do site plan review based off of.
Alec, wasn't there also a provision in the law for installations over 100 megawatts?
Look back
I
at
believe that under the new state law, installations over 100 megawatts were also going to be exempted from local control. Either way, our bylaw doesn't even contemplate units that large other than just in the over.
Right. Well, doesn't it just make sense for us to go forward with this and have it in place? Even if they come out with a regulation in 26, at least we have something to cover us in the town. If somebody comes forward and wants to go forward in one of these, if we don't have anything, then we're in the same boat we were before.
That's what the suggestion is from myself and the town planner.
That's correct. And yes, Nate, to your point, the thresholds are under 100 megawatts and over 100 megawatts.
So I'm really confused about the numbers now, and the reason I'm saying that is because our tier 2 is 0.5 megawatts, and you've been talking about 100 megawatts, so I see some real significant differences here.
So the utility exemption that's expected would trigger at 100 megawatts. My apologies that I was inaccurate at that number. I got the two different numbers in front of me there.
Okay.
The 100 megawatts is where the exemption would apply.
Okay.
It is expected that your bylaw as written will have to, in the future, integrate or somehow contemplate those regulations being promulgated by the state. But those regulations will not be ready until July of 2026. In the interim, my recommendation is to proceed with your bylaw with the minor revisions cited here provided by Carolyn Murray.
Okay, and that really applies because when we look at grid scale, right, the way we have to define it, at least on this document, it's for tier 2, which is between 0.5 megawatt hours and 1 megawatt hour, and tier 3, which have an aggregate energy capacity greater than 1 megawatt. Right?
Correct.
Okay.
So with that said, the other adjustments I think are pretty reasonable. We had actually talked about them potentially just being correctable as Scribner's errors, but we still wanted to bring this out in front of the board.
Of note too, so the article above still has your old language in it. We will need to update this article to include your already revised language. At your last public hearing, you'll note you made actually this adjustment independently on your own, and this was actually partially addressed in the same. So what we'll do is we'll apply the same revisions that are still pertinent to your revised bylaw. To your credit, you already did some of this work before before Carolyn actually got it back to you.
Okay. Mr. Chair, can we at this point in time go into some of the details that are inside of this document? Because I do have some questions.
Yeah, sure.
I'm asking for clarification on section 5.6. When you get a moment to get there, let me know. It's the fencing requirements. Are you there?
Yep, I'm just pulling it up.
Okay, great. There's right in the middle of it, I think it's like it's actually the third sentence, I believe. It says electrical equipment greater than 1000 V. I'm assuming that means volts. Is that true or not? Was that intended?
That's my interpretation, yes.
Okay. Okay. And that comes from NFPA 855 as a regulation?
Yes.
Okay.
The cited regulation.
So the next question I would have here is this is on section 6.4.
Yep.
I'm trying to understand, why this is in here and as to whether or not this is gonna cause some issues. It states here, large scale fire test data, evaluation information, calculation, modeling data. For any of the following UL 9540A, fire test data must be made available to the planning board and fire department for review. Best systems with a capacity greater than 50 kilowatt hours. Best systems with spacing between arrays of less than 3 feet. Now that would imply that anything that is less than 500 suddenly becomes a purview of, the way I interpret this here, maybe you can correct me if I'm wrong here, but I understand that means therefore that a BESS system with a capacity between 50 and 500 megawatt, 500 kilowatt would now be subject for a review by the planning board.
I will note, I believe the board has already struck that section. Your new section 6.4 and 6.5 are shown on the screen now.
That's kind of small, so can you read it for us, please?
Yes, so
Down
section
here.
6.4 now reads safety data sheets that address response safety concerns and extinguishment as part of the site plan application.
Which is our 6.5.
6.5 reads commissioning plan. The system installer or commissioning agent shall prepare a commissioning plan prior to the start of commissioning.
Okay, so we have
Shall be compliant with the NFPA.
Here's a hard copy of the edits that we
So
made.
the version that was handed in our package, I'm not faulting you, I'm just simply saying that's what I was reading here. And this is the KP draft on 5/21/2025 is what I stated earlier, and that's why I'm asking the question. Because for all intents and purposes, that would, I believe, cause some problems if that's the version that's gonna be prepared and presented as part of the ATM.
Yes, so I quietly noted this earlier, but at this point I just have to say it out loud. So Carolyn has clearly reviewed the old version of your bylaw. You worked through at your public hearings with Mark in particular, a much more complex and complete bylaw.
Okay.
We will have to send this to Carolyn for further review. I note that because already some of the motions and revisions that Carolyn's given you, you've already addressed. And so, for example, if I jump over to the other warrant, it doesn't read what this reads here. You've already addressed these comments, you've already addressed these concerns, and completed a more well-rounded bylaw, and we'll have to rush that to Carolyn for her to take a second pass at to
So
confirm.
let's be very, very, I mean, thank you for pointing that out, but again, I think this points out to the problem that we had last year, where we had inconsistencies in the versions that were presented to the planning board versus the ones that were delivered as part of the ATM. We just gotta have to be very, very careful in terms of what's being presented, otherwise we may end up being in the same situation as we were last year.
Yeah, that's
No.
correct. We'll make sure that's clarified and corrected before it hits town meeting floor.
Thank you.
Mr. Chair,
Yes, go ahead.
I do take a little bit of offense to that we would say there were version legal issues. That's not what happened at all last year nor this year. But moving further, the legal counsel can only review the revision in which she was sent. Upon receiving this, we put it in the warrant. It was supposed to be done by a certain point in time, and we were flirting with a deadline. I did not even have the version, you guys met to discuss this after the deadline to get legal counsel this document. So I just really request that people be careful placing blame here, because there's blame to be placed in every direction.
Nate,
Thank
this is Nate, this is not blaming you, not blaming, it was a circumstance that caused some significant issues last year and a lot of confusion last year, because in all frankness, the version that I think we had reviewed and the version that we eventually saw in the ATM were different. As to what the source of that difference was or why that happened, I'm not blaming anybody, it just so happens that that was the case. So I'm just saying that what happened last year, let's make sure that we don't have another repeat of that, because that will be very unfortunate.
All right,
Upon
I think we've had
vote-
enough discussion on this particular item, and we will be cautious to make sure that the proper version is in the warrant going forward. So I'm gonna limit further discussion on that and move us ahead.
Mr. Chairperson, I'll jump to Article 27.
Yes, thank you.
Just to close that out, if you guys can get me the version that you want sent to legal, I can literally send it from where I'm sitting right now.
That's good. We will send that to you by the end of the night.
Thank you.
All right, Article 27. So what I've done is I've inserted the changes that Carolyn has noted in the bylaw where they are still pertinent. So we're going to jump comment to comment because that's how I flagged them out. So you'll see here Article 27. This is your accessory dwelling unit bylaw as you have last revised it. You will note that Carolyn has cited a request to amend section 2.6 to include this language at the conclusion of the existing sentence, right? Provided, however, that if the ADU or any portion of the lot on which the ADU is located is within 1/2 mile of a transit or bus station, no additional parking space shall be required for the ADU. I recommend the board accept this revision. It simply states the unstated part of the section. So it's saying the inverse for the purposes of stating it. And that ensures the Attorney General cannot misinterpret the section.
And just also bring up from Alec and I's discussion when we initially went through this, that's obviously something that's not really relevant at the current moment, but is an issue that the Attorney General could potentially hop on to flag or deny the bylaw as it is proposed.
So if there's no comment on that, I do want to also note, Carolyn had raised a particular concern as well over your proposed limit to the size of an accessory dwelling unit.
Yeah.
In our discussions and in development of the bylaw, the board expressed interest that you would like the ADU to be defined as the lesser of half the gross floor area or 1,000 square feet. You'll note the state protects accessory dwelling units up to 900 square feet. However, through our robust discussion, your intent was to remain at 1,000 square feet as it is in the bylaw today.
Right.
And I advised you that that is acceptable because that is less restrictive,
Yeah.
not more restrictive than the state bylaw.
Right.
Carolyn has noted and recommends bringing it down to 900 square feet. However, I disagree with her assessment. I don't think it's going to in any way lead to critical failure of your bylaw. I think what would happen here is that the Attorney General may simply reduce your 1,000 square feet to 900 square feet. I don't believe this to be a critical failure of the bylaw, but if the board thinks it's not worth taking the time and risking to submit, we can reduce this to 900 square feet very quickly and easily, but it's a decision left to the discretion of your board.
All right, to kick off the discussion on that section, my feelings are similar to the town planners. Whereas the state had set the 900 square feet as the minimum. If we wanted to allow more, we're not going against what the actual presentation from the state is. We're going above and beyond. And if they were to pencil it, it probably would just be to pencil the specific size.
I'm okay with that.
Well, I understand what you're saying, however, I just wanna make sure that I understand. Your point, Christopher, Mr. Chair, is that that's the minimum. It's not, the way I think she states it here, it says it's half of the gross floor area of the principal dwelling, or 900 square feet, whichever is less. So basically, I think it's the opposite, it's actually the maximum, not the minimum. I wanna make sure that we're not gonna get into trouble for exceeding therefore the maximum. So, I understand what Alec was saying, and so, is your position, Alec, that this is not is not a true maximum? It's sort of like, are these guidelines, or what is it? I'm trying to understand where the 900 number comes from.
Under the state's definition, the maximum size would be 900 square feet. You are giving a greater maximum, which is less restrictive inherently than the state bylaw. I believe that less restrictive is acceptable.
Gotcha, okay. So I would also side with our chair that we should probably leave it at the 1,000 as we had before.
Do we need a motion?
No, not yet, I think.
We can just run through the feedback, and then at the end I can incorporate any changes necessary.
Okay.
The other one,
And that is all the necessary revision work to that article.
one second, there was one additional item here that was mentioned, and that was section 1.3. Right?
3.
It says here, the ADU may be attached or detached on the same lot as the principal dwelling unit or on an adjacent lot under common or ownership. I thought we had said that that's not going to be the case.
That's correct. So as discussed with the last article, we'll insert your already revised language and ask Carolyn to review that. You've already addressed that comment that
Correct.
Carolyn had noted.
Okay.
So you're saying 1.3 is actually struck out, right, completely?
That's correct.
Thank you.
Right, any further discussion on that article? All right, moving forward.
Okay. I will bring up, the next one that I have is Article 29, which is your site plan review bylaw. Bear with me, let me know when it shows on your screen.
It's shown.
Okay, thank you. I'll zoom in so that we can get a little bit better clarity on it. All right, so the first comment, legal left, legal counsel has recommended that you do not require the recording of your site plan decisions. I entirely leave this decision up to the board. I will note that as a planner, my personal preference is to have every decision rendered to a property recorded with the Registry of Deeds. It makes our staff component a little bit easier, but I will be fully transparent and note that there is a few $100s difference in recording fees. The more things you require an applicant to record, the greater cost you're burdening onto your applicants. So that's why I leave it fully to your discretion. It's not something I would hold so fast to, but I leave it up to you, and I do think you should discuss at least briefly whether you think it's worth the few extra $100 you're putting on the applicant to keep these decisions recorded in one place.
Is it really a few hundred? Isn't it usually just $75 for a miscellaneous document?
It's typically 2 documents. It'll be the final site plans themselves as well as the written decision.
So it's $150?
Roundabout. I can't remember if a plan set itself costs more.
So I generally like the idea of having to have these things on record, or the reasons that Alex had stated.
I agree with that.
I think so too.
But also at the same time, it wasn't a hill to die on.
I agree with that too, because a lot of times things get missed if you don't document it.
Francois or Erica, any preference?
I think it should be recorded.
I'd agree.
Okay. So then I will strike this proposed revision by Carolyn, and we will leave this section as it was originally written.
As a live update, the documents have been forwarded to legal counsel.
Thank you, Nate.
Well, that was
Right.
easy.
And then additionally, Carolyn notes the proposed revision to section 9.7. So the way that we have written section 9.7 would require that the decision of a board in the case of site plan review would have to be appealed directly to land court. What this does is it reduces the ability, or I should say prevents the ability of someone appealing your decision to the local zoning board of appeals. I originally proposed that because many towns have tried to get away from this. It's effectively, you might be pitting 2 boards against each other, and that gets a little messy at times. But that's also what the ZBA is there for. They're a quasi-judiciary board, and from what I understand, you do have a separate and independent zoning board of appeals, so you do have a separate body who can take an unbiased review of planning board decisions. The way Carolyn has written it, and as it shows on your screen now, would allow someone to seek a building permit and then appeal that decision to the zoning board of appeals before going to court. There are some benefits to that. At times, it reduces the likelihood of going to court, usually if the ZBA ends up finding in their favor instead. But I leave it to the board's discretion if you would prefer that your appeals go directly to land court, or if you would like the ZBA to be able to take a pass at your decisions first.
In the past, it's gone to the ZBA.
I understand that. My question is, since you're the one who's been at the ZBA for the longest, how effective, and I know this is very, very prejudiced,
It actually puts the board, the ZBA on the hot spot,
okay,
but the ZBA looks for specific things like hardship, you know, how's it gonna affect the town and the neighbors, and, you know, and there's specific things that we have to look at. where people have come in front of the board in the past and we've denied the application because they didn't come in conformity to what we have to look at. So it's kind of hard for everybody on the other board, but it's a good reason to go there. Cause sometimes the regulations don't fit every need.
Okay.
It's also much cheaper for the town in the long run.
Yeah.
If an appeal goes to the ZBA instead of the land court.
Yeah.
That's cheaper for the applicant.
So it's an
too.
opportunity for us.
I think it's a great way to mitigate some of the potential litigation that could result from this here.
Yes.
So I would be very happy to entertain that we incorporate that personally. I'll let my fellow planning board members express their opinion too.
Well, it sounds like the consensus is to retain this section and go through the full administrative appeals process, correct?
Yes.
Indeed.
All right, so we would accept this revision as proposed by Carolyn. All right, that goes through your 3 core articles. Now, bear with me. I will pull up KP Law's feedback on your floodplain bylaw. Leanne, can you remind me, when did the DCR reps say they would be able to take that second pass at the bylaw?
She said next week, she would take a deeper look, but upon first glance, she just asked that we were keeping that site plan section at the bottom.
Yeah. The subdivision section,
Yes,
correct?
I'm sorry, thank you, yes.
Okay, all right, so I'm gonna bring back Carolyn's feedback directly on this bylaw. In the look I've taken at it so far, Carolyn has provided you several Scrivener's revisions. So you'll see, for example, she's taken out the words city and ordinance. Those are typical of the city's bylaw. She's looking to regulate this back down to a town. She's striking miscellaneous words that no longer be in there, and correcting sections where they don't necessarily point to the right place. What I would recommend the board do in this instance is accept Carolyn's feedback, and then we can forward the draft with feedback to the same DCR rep, and they'll provide feedback on the changes that Carolyn's made as well.
Okay.
Any objection or additional discussion?
I have none.
No.
Nope.
Excellent.
I will incorporate those changes, and Leanne, I'll provide that back to you so you can forward it to DCR, okay?
Mm-hmm.
All right. Thank you, everybody. Those are your 4 bylaws. I know we had to make those last couple tweaks. We gotta just make sure the updated versions are in there. Rest assured, we'll get those in there. Nate's already, as he said, he's already sent those off, so we'll get Carolyn's second pass at them, but rest assured the correct version will be in there, and it will go through town meeting.
Very good.
Sounds good.
Now, we had actually passed over the planner's report item. I don't believe we have a planner's report for tonight. Am I correct on that? I believe that was just our planner's report.
I've got exciting feedback to share. Just last week, or actually earlier this week, we had a brief meeting on the Sand Pits project, a kickoff meeting, as well as a kickoff meeting for the commercial development project with those 2 separate working groups. Both were very successful, productive meetings. Our 2 consulting teams, MRPC, as well as Niche Engineering, seem to have a really good handle of the scope, and expect exciting public engagement to be announced very shortly. I myself have marching orders of preparing questions and getting stuff ready for the commercial development stuff, but I'll let Nate or Chris as well, or Leanne, speak to anything additional on those.
I think that's a great summary. That's also a good reminder. I was present at those meetings, and we did have an excellent selection of people from around the community that were participating in those advisory groups. And those are set up as advisory groups to the town administrator. I'm really looking forward to what comes out of that.
Sounds good.
Anything else on that?
That's all I got.
All right, so moving on to old business, I believe we have the issue of the plot planner still on the table. Leanne, did you want to give us an update on that?
Sure, I spoke to the accountant to get a more accurate representation of what was in our revolving fund. And she asked that I give her some additional time because we've just hired a new accountant and that accountant.
Leanne, I can check your revolving fund right now. I have the BVA open.
Yeah, but it's not accurate is what Mary said. She's concerned about whether everything has been added accurately or not. So she's had asked me to come back in a couple weeks after the new accountant has had time to make sure everything's balanced correctly and give an accurate balance.
How much in planning board revolving funds have you taken in the last, say, 4 months, 3 months? The last post for revolving cash and the other things that Kelly did before she left was 227.
There has been payments and expenditure since then, but not.
Then you are correct, Jude. Then you are correct, and I'm sorry I spoke up.
That's no, that's okay. So I will come back once we have that reconciled. So I'm just tabling it, I would say.
So we need to table this issue until we can find out.
Yeah.
Yeah, I mean, we can do that. And in addition, I think we were still exploring what the true use by the planning board is of this plotter / scanner.
Mm-hmm.
Because we felt that it was not necessarily something that
We need.
the planning board really truly needs, because we can request the information be provided electronically anyway.
Yep.
It seems like the other two boards are going forward with it anyway, and I'm not gonna be policing it, so.
All right, but we still have outstanding issues before I make a decision on it, so let's keep moving. All right, so next on the agenda is the additional public comment. The matter is not reasonably anticipated by the chair. So under this one, I wanted to mention to the board that I've been nominated as the next chair of MRPC, and that I am the only candidate on the slate for that at the next upcoming meeting of the commission. So barring any surprises, we'll see how that goes, but I'm looking forward to deepening our relationship with MRPC and helping MRPC get ready for the next couple decades.
Well, congratulations.
Let the good times roll, right?
Yeah, thank you. Right. Any other additional public comments or comments from the board?
I have none.
So quick talk about logistics. I mean, we have the ATM on June the 2nd. Today is May 22nd. Anything that has to happen between now and the ATM, I mean, obviously we have email communications, but is there any other reason why we may have to meet in order to review anything? I just wanna make sure that we're fully prepared for the upcoming ATM.
I think it's pretty unlikely. Alec or Leanne will probably reach out to see if there's anybody else who wants to speak to or read any of these articles or amendments when we get to the floor, so that I don't have to do it all myself. But other than that, I don't foresee anything.
Gotcha, thank you.
Excellent. Well, with that, would somebody like to make a motion?
I'll make the motion to adjourn.
I'll make a second.
Right here, okay. Beautiful. Calling a roll call vote.
Steiger, aye?
Dak, aye.
Holman's eye.
And the chair is aye. We are adjourned. Well, thank you very much.